Right, hello again everybody, and here we are with another podcast to do with the Renters' Rights Bill. In this one we're going to be talking about arrears, how that's changed in the bill, what it means moving forward, and generally how landlords are going to have to react. So I'm joined today with Laura, who's our Head of Client Accounting, and Susan, also my wife, who is MD of Cope & Co. So as usual, we're going to play a video that's already out there, and we're going to sort of chat about that after. If you've already watched the video, feel free to forward. We can put a chapter marker in the video when it's live. So yeah, let's watch the video and see what it's all about. So, big one. How do you get your property back if the tenant is in constant arrears? Now, in the bill, there is a major update for the grounds for possession regarding arrears. So rules are going to be tightened to protect tenants who fall into arrears. And they're going to do this by increasing the mandatory threshold for eviction from 2 months to 3 months. And they're also going to extend the notice period to inform a tenant that proceedings are going to start from 2 weeks to 4 weeks. Now, in English, this means that the tenant needs to be in 3 months of arrears before you can act. Excuse me. And then you have to wait another 4 weeks before repossession proceedings can even start. So these new protocols for repossession will obviously impact a landlord's ability to address non-payment of rent quickly. 3 months arrears plus 4 weeks notice, it's effectively 4 months of arrears before any proceedings can actually begin. Now, there are actually 2 grounds for rent arrears that can be used for an eviction in the Renters' Rights Bill and under Section 8, and it's important to distinguish between the two. So ground 8 is a mandatory ground for possession in a Section 8, and this can be used when a tenant is in repeated rent arrears. It's the one I've just sort of mentioned. Now, for this to apply, the tenant must be in arrears of at least 3 months at the time the notice is served and at the time of the hearing. Ground 8 does not apply if the arrears are to do with non-payment of universal credit and late payment of benefits. In this case, the landlord will have no recourse. Ground 10 is a discretionary ground for possession that allows a landlord to seek possession of a property if the tenant is in rent arrears of any amount. Again, for this to apply, the tenant must be in arrears at the time of the notice and at the time of the hearing. Now, that sounds a lot easier. However, remember, if a mandatory ground is proven, possession will be awarded. If a discretionary ground is proven, the court will still have discretion based upon the individual case whether to grant possession or not. So the government's intention with these new longer notice periods are to give tenants greater security and flexibility in challenging or addressing financial difficulties, but obviously from a landlord's point of view, they delay an ability to regain possession. A robust rent guarantee policy has never been more important for landlords to have in place. It will be an absolute must when this bill becomes law. Realistically, these procedural changes extend the timeline for possession. It's undoubtedly going to be lengthened. Landlords may face months to over a year even before they can regain control of the property. Court backlogs combined with procedural requirements for evidence in arrears, adherence to all compliance steps, contribute to a potentially lengthy and costly repossession process. Now, fortunately, a really robust rent guarantee policy will have legal cost cover. Now ours has £100,000 worth of legal cost cover. Again, this is going to be vital to protect against lengthy and costly repossessions. The shift emphasises the importance of early, proactive tenant engagement when arrears are at a minimum, at a very early stage, to try and nip it in the bud effectively, as well as the requirement for precise record keeping to avoid extended financial disruptions due to non-payment for a landlord. Now, it's clear that these grounds for possession regarding arrears have been strengthened enormously on the side of the tenant. As I've said before, understand the notice periods and timescales, understand what they mean, amass as much evidence as you can to support your claim, and be very organised and meticulous in your record keeping and audit trails. Remember, we can do all that for you. That's what we're here for. And also deciding which of the arrears grounds to use, if that's the way it's going to go, is also a very important decision, mandatory versus discretionary, etc. Well, that's it. Is it all bad news? What do we think about the actual rule changes? Oh, just bearing in mind that I say this all the time, the bill isn't law yet, so there is a chance that these things could change. With this particular part of the bill, very, very undoubted, it's not going to change. So I think we are where we are with this. So I just want to talk about the two different grounds to start with, because I think that's really important to understand. I mean, what's going on at the minute in terms of Section 8 and arrears?
Well, we're probably still using the Section 21 at the moment in most cases, or both. We're using, because you can use Section 21 and a Section 8 for repossession at the moment, or for recovery for arrears. Section 21, the main difference between the two is the cost. So it's more costly to issue proceedings through a Section 8 than it is the Section 21. So that's something to bear in mind. But in terms of the grounds, they're not changing. It's the same as it's ever been so that piece of legislation isn't actually changing. It's just going to be relied on more.
Yeah. So the process isn't changing. It's just going to be like it's the only way to evict tenants on arrears.
The biggest issue, I think, is when it gets to court, isn't it, really, Laura? Yeah. Because you've got a 10-minute hearing. Your initial hearing's 10 minutes. So unless you can prove your case in 10 minutes and the other party either doesn't turn up or doesn't argue, then you will probably get an award that day. Otherwise, it'll be relisted and you'll have to go back whenever the court's got time to actually listen and allow a longer period. What is it normally now when they go back? An hour or half an hour?
I mean, it varies, but yeah, generally you get, like you said, 10 minutes, but if it's relisted, maybe half an hour, because there's going to be a defence, so they're going to need more evidence, more discussions in court. So yeah, really important to have all of your evidence piled up and ready.
It's an underlying theme of the whole bill, isn't it? Audit trails, meticulous records, evidence, documents served correctly, because as you say, if it's not, it's out the door, and then you've got to relist, and away you go and start all over again. I think really another important bit is, and I know you're on this all the time, is the first sign of arrears. It's just really important to get on that phone and find out what's going on. Try and nip it in the bud. Try and find out what the situation is,
and work together, because obviously court's the last thing anybody really wants. It's not good for anybody. It costs more money, so the money that's being spent in, whether you're negotiating an early release for the tenant to just sort of walk away if it's, job change, loss of job, or circumstances that mean that there's just no way they can afford that rent. So it just means that you've probably got to negotiate more and think about the implications, minimise any, mitigate the loss as much as you can, really.
You think sort of more deals will be done? So, for example, if somebody's in 4 months rent, obviously you're thinking to yourself, or 3 months rent, you think to yourself, right, I'm going to have to serve Section 8 here to get it. But, you know, is there a circumstance where tenant could speak to landlord could speak to tenant and say, look, if you can pay half, I'll write the other half off?
It's already happening, Darren.
Yeah,
That's what a lot of the rent guarantee schemes are doing. They're actually paying people to leave the property because it's a more effective, less stressful and efficient way to actually gain repossession of the property. So that is already happening outside of the courts.
It's going to increase.
Yeah, more
it's going
than
to become
likely.
more popular because of what's going to happen.
Yeah.
I
mean, I want to touch on what you said in the video about the rent guarantee. We've got probably a good 40% of our landlords that have the rent guarantee policy. So they've already got a peace of mind in terms of they're going to get the rent, they are going to get possession of the property, whether it be through the courts or through negotiation with the tenant to go early. None of that will have to be done by them. The insurers do all of that. So I do think it's a really important fact. If the tenant hasn't been in persistent arrears over the course of the last 6 months, then you'd be able to add this policy on now anyway. So you haven't got to wait for a new tenant to actually take this policy out. It's something you can cover yourself for now.
Tenants, do you think the tenants are more aware of what of this bill? Because I know previous legislation. I mean, I'm talking even back to the tenancy deposit laws that came in 2007. People still don't know that the tenancy deposit's got to be registered within 30 days, etc., etc., etc. I mean, if it was me with 5 weeks' worth of deposit, I'd want to know exactly what's happening to my deposit. But they're still unaware. Do you find with this bill that the powers that be, the government, your generation rent, your shelter, and trying to make tenants more aware of what's going on with this bill? It's to protect their rights at the end of the day.
Yeah, absolutely. I mean, when you just touched on deposit laws, you know, we still have tenants now offer to pay a higher deposit for whether they're having a pet or, you know, different circumstances, and we have to remind them that they can't do that legally. But yeah, no, there's definitely more tenants aware. You know, conversations are being had all of the time, especially, you know, rent increases and things like that. You know, it makes tenants speak about it more, and yeah, then they're definitely more aware of this and the changes that are coming up.
Yeah, because I know sort of landlords in the past have sort of got away a little bit with not sticking to the legislation, but nobody's questioned it because if you don't know the legislation exists, how do you question it? I think this one is different. I think there's far more awareness of what's going on, which makes it even more important to actually stick to the rules.
Yeah, absolutely.
And be compliant. But you reckon the levels of arrears, I mean, we took, obviously pandemic times was when it was probably the highest. What sort of happened since then, last 2 or 3 years?
Yeah, I mean, they came down a lot, you know, the last couple of years. You know, we did still have a few tenants that were still paying back from the pandemic, mainly people that were self-employed. But I would say over the last year or so, you know, cost of living and everything else, it's put a massive strain. Landlords are increasing rents now more than ever with mortgage rates going up and things like that. So people are definitely finding it a lot more difficult. So we just had Christmas, New Year, January is a tough month. So arrears, they're high at the moment. I think I did 5 or 6 claims last month, which, you know, just goes to show. But for those landlords, you know, they've got that peace of mind that the rent is being paid.
With the rent guarantee.
With rent guarantee, yeah, of course.
You mentioned mortgage payments there. Obviously, absolutely vital. If you've got you know, borrowing on your property, you've got to keep that mortgage payment flow going. And you know, you need your rent.
It's times are tougher for everybody, not just tenants. You know, the landlords are feeling the pinch as well. Everybody's feeling the pinch, aren't they? So
yeah, and it sort of gets me a little bit because obviously the rhetoric in the media is that, you know, landlords are putting rents up, this, that, and the other. At the end of the day, it's the market that decides the rent. It's the market that decides what the market rent should be.
Yeah.
Landlords are just following the market.
Yeah, and their agent's advice.
Yeah, exactly.
Day,
so it's, you know, it can get a bit sort of lost, that can, which is really important. Yeah, so I mean that's probably enough to talk about it. Just if you need to get in touch, give us a call. The rent guarantee policy, that's included in our new Let Simple service. It can be bought as an additional add-on to a fully managed care service or a rent collect service. It's going to be vital. If there's any updates or any changes to that particular part of the bill, we'll let you know. But as I say, don't think it's going to happen. So yeah, thanks for that. Any questions, please give us a call, and we'll see you next time.